Good evening, everyone. It's really nice to see so many people here tonight. Lovely to see so many familiar faces, but welcome. Great to see so many new faces here as well. So on behalf of Badia Perry, welcome tonight to our seminar on defect claims. What's the difference between a claim on the Home Building Act versus the Design and Building Practitioners Act? For those I haven't met, my name's Sharon Levy. I'm a partner in our construction and strata team. Just a bit of housekeeping before we get underway. The amenities are just on the left there. Ladies first, then the lifts, and then the men a little bit further down. If you can all please turn off your mobile phones or otherwise switch them to silent. If you do want to ask any questions throughout the session, please stick up your hand or otherwise wait until the end, but we do welcome questions throughout. We do want it to be an interactive session. I'll start firstly with an acknowledgement of country. So I'd like to begin by acknowledging the Gadigal people of the Eora Nation, the traditional custodians of this land. I pay my respects to their elders, past and present, and recognise their continuing connection to our land, our waters, and this culture. I extend my respect to the Aboriginal and Torres Strait Islander people here today. So let me introduce you this evening to our presenters. First of all, George Zakos. He is the MD from Prominent Group and a construction consultant with over 35 years experience in contract management, project planning, and dispute resolution. He is a grade 2 arbitrator, court referee, mediator, and accredited adjudicator, and has been appointed in more than 200 building disputes. George has provided expert evidence across multiple courts and has been active in the industry throughout the MBA and the Institute of Arbitrators and Mediators Australia. Welcome, George. George Drakakis is a director at Prominent Group, specialising in building defects and construction disputes. He's known for his expertise in forensic analysis, particular water ingress and defect rectification, and regularly acts as an expert in complex matters. George also shares his knowledge as a lecturer at UTS. Welcome, George. And just a little bit about me. I specialise in strata law, property disputes, as well as building and construction. I've had the opportunity to work in a wide range of matters and clients, including developers, builders, consultants, owners corporation, and homeowners. I've worked with both of our presenters in the past, either engaging them as experts myself or as experts on the other side, at which time I like them a little bit less. So let's make a start. So as I said, I'm talking tonight. I will first of all kick off with the different types of claims. So it became a little bit more complex with the introduction of the Design and Building Practitioners Act in 2020, because now we have two avenues of claim, one under the Home Building Act and then the other under the Design and Building Practitioners Act. So I'm just going to take us through tonight the differences and similarities of each of those claims, because often it is confusing. And then the Georges will take us through what it means from an expert point of view to prove each of those claims. So defect claims under the Home Building Act. Now, these claims are made as a breach of the statutory warranties which are set out under that Act. The warranties are implied into all residential building contracts. So we're not talking about contracts for other work, we're talking about residential building contracts. Generally speaking, the contract may have a clause in the contract which specifically imports the warranties into the contract. If it doesn't, the warranties are automatically imported into the contract. So even if you've got a contract which does not refer to the warranties, they are there and they need to be complied with. There's no contracting out of them. So even if the contract says and the statutory warranties do not apply, that provision of the contract is void. You cannot contract out of the statutory warranties. The warranties are there to protect consumers. And so not only the current owner within which that contract might be made, but all subsequent owners. If a contract is made between a developer as principal and a builder, then you've got the warranties that apply. But then also, once the developer sells the development, those warranties still exist to the subsequent owners, to the subsequent homeowners, or the lot owners or the strata scheme. So what are they? I won't go through each of them. This is them listed here. The primary one that a claim would be made under is the first one. The work is done with due care and skill. If there's a defect in the property, then spoiler alert, generally speaking, it won't have been done with due care and skill. And as I say, 18C and 18D, it allows subsequent owners to rely on the warranties as if they had contracted with the builder and developer themselves. So what do the warranties apply to? So the Home Building Act applies to residential building work. This is distinct from the Design and Building Practitioners Act because it applies to everything, not just residential building work. So residential building work includes new buildings and dwelling, renovations, extensions and repairs. And a dwelling is defined to be a building or part of a building, as long as it's been designed or constructed for use as a residence. The limitation periods. So proceedings must be commenced. This is distinct from, I told the builder about my problems. A lot of clients might come to us and say, I told the builder I'm all good. They aren't. Proceedings need to be actually commenced, either in NCAT, the New South Wales Civil and Administrative Tribunal, or otherwise the local district or Supreme Court, depending on the value of the claim. So it's 6 years from the date of completion for major defects. For everything else that is not major, they've only got 2 years. Now, a lot of people don't know that an extra 6 months can be tacked on to these warranty periods if that defect only became apparent in the last 6 months of the warranty period. So if there's 1 month left to run on the warranty period and they only find out about it at that point, and they couldn't have found out about it earlier, they get another 6 months. So the defect period becomes 6.5 years or 2.5 years. So in terms of the major defects, what is a major defect? These ones have 6 years to run from the completion date. It needs to be a defect in a major element of a building, and we'll talk about what a major element is in a moment. So the defect needs to be in a major element of a building. And the second limb of the test is that that major defect, with the defect in the major element, causes or is likely to cause the inability or to inhabit the building, or the destruction of the building, or a threat of collapse. So a lot of people will come to me and say, it's a defect in waterproofing, which is a major element, therefore it's a major defect. Often that is the case, but the evidence also needs to show that that defect in the major element will result in either 1, 2, or 3 listed down there below. So in addition to a major defect in a defect in a major element, it can also be a major defect if it's a defect prescribed by the regulations. An example of that, B and C, would be cladding, for example. So what is a major element? The biggie here that we will often rely on is waterproofing. Waterproofing is a major element in a building. Others are internal or external load buildings, so structural elements, fire safety system, or anything else prescribed by the regulations. If it doesn't fall within the definition of a major defect and have 6 years, then everything else will be a non-major defect and have a warranty period of only 2 years. So this is where the expert evidence really comes into play as a lawyer, and I depend on that expert evidence to tell me whether or not it meets the definition of a major defect as defined by the legislation, or otherwise, if not, it's a minor defect or a non-major defect. So when do the warranties start? So we've got a 6-year or 2-year limitation period from the date of completion. It is different for strata buildings versus class 1s, residential houses. So for strata buildings, it's super easy. the date of issue of an OC. That is less complicated now than it used to be because we no longer have interim OCs. So you've got a final occupation certificate, and it's the date of issue of that occupation certificate will be the date of the of completion. For any other residential building work, Class 1 houses, or anything else that falls within the definition of residential building work, it's a little bit more complicated. Completion will be the date within the meaning of the contract. If that doesn't provide when completion is, completion will occur when there's been practical completion of the work. So generally speaking, that is when the work is complete, except for any omissions or minor defects, which prevents occupation of the dwelling effectively. Now, that practical completion will be the earlier of either the date the builder handed over the property, the work, the date the contractor last attended site, or the date of the OC. So it's the earlier of those three items. So if someone comes to me, they're the owner of a house that's been completed, my first question is, when was completion? Often they will say, OC was issued on this date. That is the last possible date that completion was. And a lot of people fall into the trap of thinking OC was issued on this date. I've got 6 years from now until then. It's often actually earlier. And you should not assume that completion is the date of the OC, because if a builder comes along and can prove any of those other matters, so I last attended site 6 months earlier than that. It's not my fault that it took them 6 months to get the OC. Homeowners need to be really careful of when their completion date was. So what if the work wasn't completed? In that event, it will be the date the contract is terminated. So your warranties will run from the date of termination. Or if it's not been terminated, the date that the work ceased. Or if it never started, then the date of the building contract. So the date of completion can always be a tricky one for clients. Often it will come down to evidence as to when those matters, when completion can be proven. Moving on now to claims under the Design and Building Practitioners Act. So this act came in 2020. Since then, builders and developers have been pursued for defect claims under both the Home Building Act, applying to only residential, but also under the DBP, which applies to a broad range of building classes. It imposes a statutory duty of care on those who carry out construction work. And I'll take you through in a moment the definition of construction work. For various reasons that I'll take you to in a moment, but also that I'm sure our other presenters will talk to, a claim under the DBP Act is actually far more complex to make than a claim under the Home Building Act. For that reason, generally, we will recommend to clients, if you've got a claim under the HBA, just run with that. It's far easier to prove, technically supposed to be quicker, and you would only run with a claim under the DBP Act if you've got issues with the warranties or you want to make claims against other parties or there's some other complicating factor. So generally speaking, the majority of our matters are still run under the Home Building Act for a breach of the statutory warranties. So the duty of care is found in Section 37 of the Act, and it says that a person who carries out construction work, there's that term again, has a duty to exercise reasonable care to avoid the economic loss caused by defects in or relating to the building or arising from the construction work. Sounds fairly simple. The courts have really made that application of the duty of care particularly complex. But in any event, it's really necessary to go through the elements of what is construction work to determine exactly what the duty of care applies to. The definition of building can be seen underneath there. Again, it's the building or part of a building but it pretty much includes most types of dwellings. So the definition of construction work, it includes building work, the preparation of regulated designs, which I'm sure anyone who has had anything to do with regulated designs hate with a passion, the manufacture or supply of building products. Subsection D here is the most controversial. So it's the supervising, coordinating, project managing, or otherwise having substantive control over any of the work in A, B, or C. Pretty much anyone who steps site on a construction site is liable or is performing construction work under the DBP Act. Interestingly, the cases since the introduction of this legislation have found that you actually don't even need to be supervising, coordinating, project managing, or having substantive control to be performing construction work. As long as you could have been performing, supervising, coordinating, project managing, you are still liable. So for example, if you've got a director of a company, building company, for example, director of a building company could, if they wanted to, supervise, coordinate, project manage. They are still performing construction work. Now, whether or not they are liable is a matter for evidence. The extent to which they are liable is also a matter for evidence. So it isn't necessarily going to mean they are 100% liable for that economic loss that the plaintiff has made a claim for. It may be they are liable for a proportion of that. But in any event, they are still liable if they could have been supervising. It doesn't matter that they never did.
How does that apply to a contract administrator / superintendent of a head contract?
It hasn't been tested, but theoretically, they can be liable. Project managements, for example, can be liable. Superintendents.
Superintendent doesn't project manage or supervise.
No, but it depends on their role, their contract, for example. What is their role? What is their obligations under the contract? But if, for example, there was a, hypothesize for a moment, if there was a claim made that the superintendent needs to assess as to whether or not it should be approved. If there were defects on site that the superintendent had he could have or she could have directed the builder to correct the work. If the superintendent could have directed the builder to use different materials, then perfect. Okay. Yeah, I hope I've given the right answer. but theoretically, yes, a superintendent can be found to be supervising, coordinating, project managing. It's going to depend on the evidence. So the duty extends to all buildings. Originally, we thought that it only applied to the same classes of building that regulated designs apply to, which is in a different section of the Act. It's since been determined by the court that it applies to all construction work. It's owed by every person who carries out construction work. That includes employees. So even if the contract is with a company, an employee of that company carrying out construction work is liable personally. Their assets are personally liable or at risk. Directors, it doesn't matter who the contract is with. If they were performing construction work, then they are liable. It's owed to current and subsequent owners of buildings. So similar to the Home Building Act, it's owed to owners down the track. Again, the duty can't be contracted out. So if you've got a contract that tries to contract out of the duty of care, or otherwise say the duty of care doesn't apply here, that clause will be void. And here's the kicker, it's owed retrospectively. So the Act came in 2020. It applied for 10 years before that. So I have a lot of builder and developer clients that when that Act came in were thinking, what was I doing 10 years ago? it applies 10 years retrospectively. In terms of how long the duty lasts, it's a little bit different to the Home Building Act. It's 6 years from the date they become aware of the defects with a 10-year long stop. So whatever occurs earlier, 6 years from the date of when they found out about the defects. So if they find out about the defects 5 years after completion, they can make a but it has a 10-year long stop. And that the completion for this is the date of issue of the OC. So just a quick comparison then. What does it apply to? The Home Building Act applies just to residential building work. The DBPA applies to all kinds of construction work. What is the claim? Under the Home Building Act, it's for a breach of those statutory warranties. Under the DBP, it's for a breach of the duty of care. The claim will be made under the Home Building Act for against a builder and developer. Under the DBP, anyone who undertakes construction work. So it really casts that net a lot wider than the Home Building Act. Limitation period, 6 years for major defects, 2 years for other defects for the Home Building Act. For the DBP, the limitation period is longer. So it's 6 years from when the defect arose, or otherwise 10 years from that long stop, from the date of completion. For the DBP, there's no distinction between a major defect or any other defect. So in circumstances where a client might be out of time for that 2-year period under the HBA, if they were to commence under the DBP, they can claim all of those non-major defects. So really, if those non-major defects are just rats and mice, there's really nothing to it, you wouldn't bother. But if those non-major defects are quite substantial, even though they're non-major, but commercially there's a large quantum to them, it's worth it to pursue under the DBP Act. No contracting out for either the warranties or the duty of care. The evidence required under the HBA is just proof of a defect. If you've got something leaking or some water ingress, generally speaking, there's going to be a defect, a breach of Australian standards or something like that. Under the DBP, you need to prove negligence. So the evidence for both is substantially different. And that is a perfect segue for our presenters who will take us through the requirements under each the HBA and the DBPA of the different kinds of evidence that we need. So, oops.
Right, thank you. Welcome, everyone. I'll try and be non-controversial with so many lawyers in the room, which is a bit daunting, but we'll proceed. Let me tell you a little bit how the topic came about in our office. We do defect claims in the office, and we started getting a whole spate of DB&P claims coming in. And lawyers saying, do you do DB&P claims? Do you do LULASH claims and schedules and so forth? So we started doing some of those, and we actually, some of the guys in the office started saying, hey, listen, we need a 101 dummies on what's the difference between a HBA claim and a DB&PA claim. We need it spelt down so we can actually have a look at it. And so George and I sort of said, well, that's not a bad way of actually giving a talk. So we presented inside our company. We got all the guys together and we had a chat about it. We said, this is something we think that would help everyone else. Well, we found it interesting in trying to differentiate. Now, I got the easy part of the talk tonight. I'm going to talk about the HBA claims, and my partner George is going to talk about the DB&PA claims, the design claims. So he got the harder draw tonight. Sorry, buddy, it happens. So what I'm going to do is, Sharon touched on the issues with the HBA. I'm going to go through some of those issues, but I'm going to talk to you about how an expert looks at them, or how a building consultant looks at them as we're preparing our reports, and we get the lawyers ringing us up and saying, yes, it's a defect, but why is it a defect? How are you going to prove that? What do you need to do? And so we'll talk about that tonight, okay? So let me make sure I get this right. So with the DB&B claim, sorry, the HBA claim, the first part is 18BA. Now, that's the common one that we often see in expert reports and consultants' reports. You get the other consultant always saying it's a defect. Why? Because it's a breach of 18BA. That's what they say. Some reports don't even give you a hint as to why it's a breach. They just say it's a breach and they stop there. Well, we like to think there's a bit more detail behind that. And if you have a look at 18BA, there are some phrases in there that really do come home for a consultant. One of them is due care and skill, and we'll talk about that for a moment, in a moment. And the other one is in accordance with the plans and the specifications set out in the contract. So those lines there are fertile ground for a consultant who wants to get the evidence together. And it starts actually in the plans and the specifications. That's where it's really fertile in there, because in the plans and specifications, they normally specify the standards, that the work is to be conducted in a particular standard, and that's where the standards are listed. On the plans, they talk about the way it should be built. We often talk about due skill and care, and you get a lot of those phrases where the consultant says, oh, it's not done with due skill and care. And we talk about that. We say, how are you going to test that in court? If the lawyer says that's really nice, but what's the test for due skill and care? Now, I think we're all familiar with reference standards, Australian standards. They're the ones that are listed in the BCA and the NCC. But there are two standards that actually are subject to a lot of construction work that are not listed in the BCA. And those two standards are the Guide to Painting and the Guide to Ceramic Tiling. And the hint in the name is their guides as an Australian standard. They're not a reference to Australian standard. So when you get all these consultants who come out and say, oh, the tiles are this and the tiles are that, it hasn't been done with due skill and care. As an expert, you start saying, well, how do I prove that? How can I prove that in my report? And the way you can prove it in your report is you go to AS 3958.1. Well, how do I get that in? It's not in the NCC. I can't say he's breached the NCC, the builder's breached the NCC. The way you can get it in or think about it or start looking at it is in the specification. The specification will normally say, carry out all tiling work in accordance with 3958.1. So you straight away have a link there to consider. Same with the painting. You know, and you love those phrases with the consultants, don't you? Painting's not done in a tradesman-like manner. And seriously, you look at it and you go, seriously? What the heck does that mean? Not done in a tradesman-like manner. Give me a break. If you go to Appendix C of AS 2311, it gives you a whole test of saying, this is what bad painting is. And it lists about 10 reasons. And you look at that. And how do you get AS 2311 in? Specification. You drag it in that way. And that's how you start proving your points. The other standards are easy because they're referenced in the BCA. They're already there. You've got the hint. You know, AS 3740, 46, the external code 4654. But when you're referencing your standards, make sure you check which edition of the BCA is applicable. Yeah, we're all nodding our heads. Why do we still see reports then? Why do we still see reports that go, I went and had a look at the building last week and the applicable standard is AS 2026 in a BCA. You're going, how can that possibly be? They still don't learn. Fortune teller, whatever. So that's where, as an expert, we start looking at that. That's those two phrases in there that we actually go in and delve in. Now, if there's no specification, you say, what do I do now? Imagine this, you've been cross-examined by Sharon, who all of a sudden is now senior counsel, knocking on the door, Supreme Court judge. He'd been cross-examined by Sharon, and she says, Mr. Zakos, the painting's terrible. Yes. Tell me, you say due skill and care. When a painter learns his trade, what documents do you think he might have regard to? You say, oh, well, the manufacturers, and is there an Australian standard, Mr. Zakos, that applies to painting? And you say, yes, there is, 2311. Do you think a painter learning his trade might have regard to that standard? And you see the path that she's going to take me down. Okay, so it's not in the standards, but it's a document that everybody in the industry knows, and you try and tell a judge, yeah, look, when it comes to painting, don't worry about 2311, forget about it. You know what I mean? When that's the document that they learn. So that's how you've got to consider all this. The second one I want to talk about under this, C, a warranty that the work will be done in accordance with and comply with this or any other law. Now, the law I'm really interested in this one is the EPA, which drags in the NCC, because it says that all the work must be carried out in accordance with the NCC. Once the NCC is dragged in, it drags in Schedule 1, reference documents. It drags in all those Australian standards. So that's how it all works. Question for you to think about. I had a matter once which was fascinating in that a consultant went out there and defected something like about 130 bathtubs, because he said the bathtub detail was not in accordance with AS 3740. So I went out there and had a look, and I did my measurements. I took a look, photograph. Yep, that's right. It's not in accordance with AS 3740. So as I'm preparing my report, I start looking at the architectural plans in detail, and there is a detail there on the architectural plans that shows the way the bathtub's been built. So I'm thinking to myself, now hang on for a sec. This builder built in accordance with the plans, which is in contravention of AS 3740. He's caught between the devil and the deep blue sea, because if he built in accordance with the plans, he'd be complying with 18BA. But if he builds in accordance with the Australian standard, he'd be complying with 18BC. He can't do both. He can't comply with A and C because the architect has given him a detail that contravenes AS 3740. We had a lot of fun with the lawyers trying to work out what the issue is. Unfortunately, that matter settled. It settled, so we couldn't work it out. But it was really interesting to just try and think about that. If you ever come across that situation, think about how you would handle it. What's the best way to handle it? I know I think that'd be a great topic to talk about one day. Okay, let's move on. I know George is itching to get to the DB claim. Just with the time limitations, Sharon has been through it. She said 6 years for major defects, 2 years for other defects. And for those of you who like reading the Act, you know the definition of other major defect is it says these are the major defects, and basically anything else is a minor defect, but we call them other defect. So if it doesn't fit in those, they're another defect. In terms of liability, as I said, it's been covered. The primary is the builder, and it may also include the developer and some successors as well. But the nature of the liability here is it's the breach of the 18B warranties. That's with a HBA claim. And it's really simple. You either comply or you don't comply with the standards and so forth. And it's really good for an expert to be able to take his camera, measure, investigate, hose, work out what's going on. Now, let's talk about some of these issues, though, what a major defect is. But I want to go to this definition here first. What is a major defect? This is also fun that we've been having in the office and looking at other experts as well. It says a major defect is an internal or external load-bearing component of the building. that is essential to the stability of the building. So you got to think about the stability. The question I pose, again, rhetorical, are tiles, when people say, oh, the tiles don't have fall, that's a major defect because it affects the waterproofing system. So if you take that to the logical conclusion, you go, okay, so if all of a sudden I take the tiles off the balcony and the membrane is there, the whole membrane, the whole waterproofing system collapses. Well, not really. The membrane system should still operate, whether the tile's there or not. So just think that one through next time, whether the tiles are a major defect or not. But the BCA, the new BCA, has something to say about that, which is fascinating. We'll talk. That's a talk for another day. The other system we have is the fire system, which is pretty self-explanatory. And yes, it means even if you have a smoke detector missing in a house, that's a major defect because it is part of the fire system. And that's where you start thinking, okay, well, this is what the words say. But the next one's my favourite one, the waterproofing. The Act does not define what waterproofing is. Does not define it. So waterproofing could be what we all traditionally think, the waterproof membrane in the bathroom, in a wet area, on the balcony. The waterproofing system could also extend to be possibly the flashing system. Possibly. Could also extend to be possibly the windows, the flashing around the windows, because that stops water coming in. Could it be extended to the roof? This has not been tested yet. And this is what, as experts, as consultants, building people, we have to grapple with when we talk about it, because, and apologies to the lawyers in the room, but all the lawyers will push to try and major defect, because they want to get a bit, don't know what you mean. No, they want it all in the 6 years, because that way it's easy. It's all in the 6 years, major defect, it's all good. But it may be a defect, it may not be a defect. You have to consider these. I used to have a lot of fun with the definition prior to BCA 2025, the external walls to a Class 2 building. You look at the BCA, and those are familiar with, you'd have the provision FP 1.4 in Volume 1. We should say that the external walls have to, and the roof have to be water resistant, the doors and the openings and so forth. That's the performance requirements. Then you'd go to the operative section and you say the DTS requirements, and you'd go to F1 straight away, and there in big letters, bold, it says there are no DTS provisions for an external wall that satisfies FP 1.4. I'll say it again, there's no DTS provision. So there's no Australian standards that would operate. It's basically the performance requirements only. So that's something you got to start thinking about as well. But that comes into waterproofing. And the major issue there is it's not defined. So until they define it, it could be anything you want it to be if you can make it work and if it's appropriate. That's the important part. So those are major elements. So once you get that threshold done, you then go back to major defect, and A really sends shivers down my spine considering what an expert or a builder is up for. Apart from the fact that it says a major element of a building that is attributable to, now here we go, let's look at the words, defective design, defective or faulty workmanship, defective materials, or a failure to comply with the structural performance. So that's anything, any type of defect. You name it, line up, you're it. But the chilling part is in the last 5 or 6 words, and that causes or is likely to cause. Likely to cause. So when you think about that, it doesn't have to have manifested yet, but it's likely to cause. So when you look at a defect, you go, is that possibly going to fail? It may fail. Is it likely to fail? And is it likely to fail because of design or faulty materials or faulty workmanship? How is it likely to define? And now I'll leave this to Sharon, but there was a court case brought down where the court said that only experts, building experts, are capable of making those decisions. So building consultants or people in the industry giving reports, technical reports, can do that. That's quite a chilling part, really, because the defect doesn't have to have happened. It's likely to happen. So you've got to think about that. Most of the time we go out and we see it, we actually see the results of once the defect has occurred. And that's easy. That's easy. We have a look at it. And the other comment with when you look at the defects is please make sure that you also link causation with the defect. In other words, you go there and we see lots of reports, crack in the wall, defect, builder's defect. And you go, okay, let's break this down a bit. There's a crack there. Why is the crack there? And my favourite phrase, and I think all those people who work with me know, what has the builder done wrong for that crack to appear? What has he done wrong? You tell me what he's done wrong for that crack to appear, and I'm there. Causation. Did the crack appear because the engineer under-designed the slab and the slab deflected and the wall moved and it cracked? But the builder built everything according to the plans. You've got to work out causation, why something failed and why is it there? And always keep in the back of your mind, what did the builder do wrong? Yes.
Is the nurse place?
Yes. Like in Newcastle. Yeah, exactly. It could have been a tremor. You don't know what it is if you're near a railway line. Yes.
Isn't the builder responsible for design anyway?
No, not always. No, depending on the contract and the contractual relationship. Lots of lawyers in the room who can talk about that. But if it's a construct-only contract, like the good old-fashioned days, where you'd say, I is the dumb builder, I've signed the drawings up, you've designed it, I'm just going to build it. I'll build whatever you've drawn. That's it. Well, that's, a construct only. But with the design construct these days, that's a whole new issue. So please consider that. And as Sharon said, you've got the inability to inhabit the building, the destruction of the building, and this is the other part that does, you've got to put your mind to as an expert, or any part of the building. So it's not just everything else, it's any part of it. It could be a brick wall, it could be the paintwork. We had one claim once where the consultant on the other side said the flaking and the cracking paintwork is a major defect. We said, okay, walk me through that one. And the logic was the paint is applied to the external wall. The external wall is a load-bearing element. So straight away, it's a major element. This is true, David. We have to work through this one. And because that defect in the external wall has caused the destruction of the building or any part thereof, and the any part was the paintwork, it's a major defect. Gotta love that, haven't you? That's what you've got to deal with and think through. So consider that part, any part of the building. Dealt with that. So step one is basically identify if it's a major element as a consultant. Is it a major element of the building? And because you've got lots of room to move, okay? And then secondly, is it a serious consequence? And the serious consequences was those other issues that Sharon had brought up. And then this is really the punchline, that part A part. Consider the issue that it could be defective design, it could be construction, materials, workmanship, and it doesn't have to have happened yet, likely to cause. Okay. This is the practical test which we've discussed. In terms of major defects, these are some of the issues that we talk about. Waterproofing failure causing water ingress into habitable areas. We know about those. Structural cracking affecting load bearing capacity. Balcony instability posing safety risks. the greatest trend we've seen over the last 5 years are balustrades. The balustrades is, yeah, wobble wobble, and that's the latest craze now. Now it's balustrades. Yeah. When in doubt, go to balustrade. Just throw that in there. That'll work. And so the issue is under the Home Building Act, due skill and care, compliance with the law, and the law being the BCA and the Australian standards, the contract, the specification, the drawings, don't forget those. And the DC, yeah, development consent, yeah. Don't forget those documents. Now, I'll just talk about, yeah. This is really the areas of where you should be getting your information from as a consultant. Okay, so we've looked at A, and we've said the warranty that the work will be done in accordance with due skill and care and the contract plans. This is where we get our information, and this is where it really should be your ready reckoners. It should be the contract documents, and that's a very fertile area. And I mean that only in terms of referencing of what the builder should have done. The NCC, now we all know if there's a conflict between the NCC and the Australian standards, which document takes precedence? NCC does. NCC overrides the Australian standards, which is really fascinating now, Sharon, because in the 2025 edition of the NCC, it says that where you have a floor waste, the falls in a singular plane shall be between 1:50 and 1:80. Park that thought. Let's look at AS 4654.2, and let's look at AS 3740, where it says falls in bathroom areas can be 1:100. Let's think about that one. So if the builder says, but I've built it to 1:100, and you say, yeah, you know what? Close, but no cigar. The NCC says 1:80 is to 1:50. And you know what? The NCC takes precedence over that. Bum, bum, no deal. So we're actually, in our office, we're actually going through that at the moment. Lewis, the resident finder of faults in the codes and standards, is going through that and putting a paper together of all the anomalies between 2025 and some of the major standards. And it's just frustrating. It just really is frustrating what we have to do. But be careful of that one, okay? Because the 2025 one's not in yet, but it's on the horizon. It's going to come. And so the government will then sort of say, you had no excuse, you knew it was coming. Yes?
You have to use the NCC that's relative to when the building was built.
No. The
Because
appropriate
standards there.
Yeah, but the appropriate edition of the NCC you have to use is the one at the time that the construction certificate was applied for. So if you're putting in, if it's going to be 2025, you're putting in CCs now.
No, I'm talking about.
Years ago, you'd have to go back.
Built 10 years ago, someone's raising a problem. You've got to use the relevant.
Yeah, but that's going to be a problem in the future, though, isn't it? Isn't it? Is there going to be a problem?
It's building.
Sorry?
Talking about a building built 10 years ago.
10 years ago. No, it doesn't apply, but for the buildings to come now.
I get that moved forward, but if someone's claiming, you have to use the NCC when that building.
At the appropriate time. Absolutely. And you look at the standards that it listed in there. Yeah. So we have the NCC, the reference standards, which are those referred to in there, the non-reference standards, the handbook series, the HB series for cladding, the roof cladding, metal cladding, plastering, so forth. Industry guide to literature, and my favourite, and it's right down the bottom, the guide to standards and tolerances, which basically says anyway in about the 4th page, if this guide conflicts with any standard or the NCC, the standard and the NCC takes precedence. Because it also introduces things in there that aren't in Australian standards. Like for those who have a look at the tiling, they say, if the room is if the room has 5% drummy tiling or more, it's a defect, or 10%. You know, they flip and flop between 5 and 10. They can't make up their mind. That's just, you know, nowhere in an Australian standard does it say that, except in DAS 3958.1, it does say that floor tiles have to be 90% bonded. But then again, you say 90% bonded. Hang on, does that mean 90% of the tile or 90% of the area? What does it actually mean? And how much of it? And is it the edge? Is it the butt? It goes on and on and on. But those are the documents as an expert would be going to for the evidence to bring out and measure. I won't talk about the obvious measuring and testing and photographing. That's consulting 101, but that's where the documents are you should get. And I think on that basis, thank you very much. I will hand over to George now, who will now talk about the more difficult DBPA Act.
Okay. It's been mentioned a couple of times tonight that I've drawn the short straw because I had to deal with the difficult Design Building Practitioners Act. Nothing could be further from the truth. It's black and white. There is no grey in this piece of legislation. The truth is, nothing could be further from the truth. And the term grey resonates with me because for those of you in the room that have known me for many years, some of you have approached me and said, "Oh, George, you've got a few greys going on. What's happening with you?" And what I say to them is, I was doing really well until this piece of legislation come into play. It really is a difficult piece of legislation to deal with as a remedial building consultant in terms of regulated building designs and things of that nature. But one thing's for sure, and I need to sort of relay this message from the very, very onset. People are acutely aware of Section 37, the duty of care, because very often when designers are putting together things or people are doing work or providing the services within the industry, the term personal liability is often thrown around. That message is getting there. My personal view is that it's overstated, and often we are putting together designs or having to coordinate designs which I think are overspecified. But that's a function of this piece of legislation coming in. We don't have the cases yet. We don't quite know where we stand. So there is plenty of grey, not just my hair, it's the legislation. Sharon, before I start, I was told that we're going to finish at 6:30, but as superintendent of the evening, can I make a formal extension of time claim from the very, very on? 2 minutes.
No, you got 2 minutes to go, mate. Sorry. You have to be in mind.
You know you're in trouble when your contractor asks for an extension of time before he's even started. But anyway, I'll be able to zip through this fairly quickly. I think I'll just go to the heart of the evidence stuff. So a couple of key points there about the Section 37. It doesn't have to be under a contract. If you look at 4B, it's any arrangement. It's basically providing those services. Section 36D is the one that really captures my attention: supervising, coordinating, project managing, or otherwise. The question was asked before, does it capture superintendents? I'll answer that question very, very specifically in a few slides' time. It definitely does. It's broadly the differences, okay? I think a major difference, and I'll get to that slide a little bit later on, is that you heard George talk about major defects. We talked about limitation periods and so forth and so on. The distinction between major defects and minor defects, 2-year limitation, 6-year limitation. Because we're talking about a 10-year limitation period, the reality is now, under the Design Building Practitioners Act, you're even liable for minor defects for the full 10 years. So this is actually where I want to spend most of my time. When the legislation first came out, I must say to you that I was probably approached only a few months into it. probably in October or November of 2020, fairly early on in the piece. I was engaged as an expert witness to put on evidence in relation to the Section 37. And I said to my instructing solicitors, well, give me some guidance. It was a pretty broad brush brief. We're making Section 37 claims. I did look at the pleadings and tried to glean from that, well, where's the evidence? Where am I supposed to take the evidence? And having the background of a fair bit of legal experience, you know, I just sort of relied on my understanding and knowledge of common law principles. Okay, I can't recall now whether I went to the Civil Liability Act, but it's something that I do now. I look at those provisions because in some ways that's a codification of the common law. Is that a fair and accurate way of saying that, Sean? Oh, sorry. So I look at those particular provisions and I invite you to do so as well, because it informs you about what negligence is about. I've been involved in probably at least a dozen, maybe 15 of these types of claims in the last few years. And there's a comment that was made by quite a senior barrister not long ago that resonates with me, and that is, ever since Star of the Sea, and we can thank George for that one, ever since Star of the Sea, we've all forgotten about negligence, right? And here we are now as lawyers and barristers trying to re-educate ourselves and re-familiarise ourselves. So look, I've looked at those principles and I encourage you to do so, because in a very quick read, it sort of informs you about, well, what are you responsible? Where's the duty of care go? What are the principles that apply? I'm bringing up 5.0. Sharon, can I please correct me if I'm wrong? This would apply to builders, it applied to architects, it applied to all those sorts of people. The reason I'm bringing up 5.0 of the Civil Liability Act is this. Section 37, you've got a duty of care, but understanding negligence, you've got to go into the breach territory, right? So the question is what you've done a breach of the duty of care? So then when you look at 5.0, you've got to ask yourself, is what I've done a breach of that standard? Okay, and how do we figure that out? Well, you might say, well, I did what any other reasonably competent builder did, right? And what a court might say is, well, I'll decide who or what a reasonably competent builder is. And simply saying, well, I did what any other builder will do may not cut it, okay? This is basically saying, well, let's look at what the profession would have done and what's sensible. But have a look at this one, which is actually in the statute. If what the peer review or what industry was doing back in the time just was irrational, well, we're going to throw it out. Okay. Now, why have I brought your attention to this? This is for the lawyers and for the experts to think about. You can run these claims, you can engage an expert, but just remember, they're expressing opinions on what you were doing back then, 5, 6, 7, 8, 9 years ago. And with the benefit of hindsight and education and awareness, we all do things better. There's definitely been a shift in the industry. There's an acute awareness of responsibility and liability. So people seem to be or tend to be a lot more conservative now. But when we're making these Section 37 claims for work that happened 8 years ago, you really got to ask yourself, well, what were people doing back then? What was acceptable? And I'm telling you now, I don't think it's a black and white answer. And it's certainly one lawyers should be thinking about. And as experts, if we're expressing opinions on what a duty of care is, and I'll get to that in a moment, you've got to be asking yourself, well, what were we doing back then? Because that's the standard you're going to be held to. Okay, so like I said, I was instructed almost within a handful of months of this legislation coming out, and you know, again, with the benefit of hindsight, I look at what we were instructed to do and what formulations and how do we approach this, how do we cobble it together. It wasn't until we started getting a few cases like this to give us some guidance. Now, these cases were more about the pleadings, right? But from the pleadings, you align your evidence with the pleadings. So these principles here that have been set out in these cases, I look at them from an expert's perspective to say, well, where does my evidence have to be? I've got a pleaded case, but a case is dependent on the evidence which supports the pleadings. So as experts, it's not like we're formulating stuff, but we need some guidance on how our evidence should be laid out. What are the elements that we need to hit? Where does our evidence fit in? So in this decision, we had this stuff going on, okay? But this is early on in the piece. And I'm sure there was a fair bit of head scratching going on by lawyers. I don't know too many experts that would be reading these types of cases. But can I ask the question? How much grey is there in the legal fraternity? A fair bit, I imagine. I derive another fair bit of guidance again from this other decision from Pathburn, right? And again, it's where the judge explains, well, this is what I expect in the pleadings, okay? And for me, this assists me in understanding, well, how do I go about producing my report, okay? Some fairly interesting comments there, though. I'm going to, in my next slide, this is how I go about setting out my report, okay, in terms of the heads. When we're talking about the section 37, I've looked at these cases, and again, this is not my formulation. This is with working a number of different solicitors, a number of different barristers, and coming up with these heads, if you like, to be put in my report. We want to identify who is responsible. We actually want to say that person, okay? We set out what the risk of harm is. I set out, and I'm going to go through the examples in a minute, which will include a superintendent. What reasonable steps should the responsible person have taken in relation to that risk of harm and the specific risk of harm you're dealing with up there, okay? If the above steps were taken, would the defect have arisen / continued to exist? You can see the causation element in there, right? So I've taken that approach in terms of setting out my report, and in answering those questions, I'm trying to answer the questions which the judges are saying, this is what I expect to see, okay? Does it make me right? I don't know. The cases haven't come out, right? We're waiting. We're still in the grey territory. I'm just going to go through some examples now, okay? So in the body of our report, this is what we might say. And this is just setting the scene of what a nominated supervisor would typically do or be responsible for, okay? Interpreting plans. And as you're reading through this, I want you to think back to that section 36 definition, coordinating, project managing, supervising, blah, 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 blah. A very broad, all-encompassing definition. So site preparation, construction managers, material procurement, you can see there's a lot of decisions going on there. And this is not unique to a nominated supervisor, but ask yourself this question. Would a director of multiplex be doing this stuff? I'll come back to that. Supervision and quality control. Project completion. So when you start thinking about the superintendent, start thinking about, well, they're making critical decisions about when the work is complete. Is it satisfactorily complete? And I've got a specific example of that coming up. So I'm just going to go through now. Again, remember I said that these are the headings that I'm using in my report. The first heading, which person is responsible? In this case, we've got Ted, Jack, Sam. I've just made those names up. It might be the first defendant, second defendant, third defendant. Note that I've put in brackets these guys in the role of the nominated supervisor. Why have I put in brackets including the site manager and project manager? Well, this is the interesting thing. These guys were employed by the builder. One of them was a director, but the company wasn't so big that the director, like Multiplex, never goes to the site. The director that works on the site He's also got a site manager, and we've also got a project manager. And the reality is, I think Sharon, you said it, well, where's the evidence going to take us? We don't know. And to a certain extent, we as experts are speculating. We don't know if that director was on site. We could say as a director, you're responsible to have systems in place, and that's another category. But right now, I'm picking up these people as the nominated supervisor, and I'm clustering together the site manager and the project manager because they were the three people. Okay? What is the risk of harm? Now, just to set you the scene, when I said defective waterproofing, this specific example was waterproofing a penetration or inadequate upturn on a roof. We actually had a lot of water coming through the roof, and that's what this particular item was relating to. So what's the risk of the harm? All these things happening. Water damage, going into the building, potentially making the place uninhabitable. We're setting out here from a Section 37 perspective that this is actually serious stuff. It's not frivolous. Okay? What reasonable steps should the responsible person have taken in relation to the risk of harm that I've just set out? Well, you would have read the building contract. You need to know what the specification is, what you're required to do. Should you know what AS 4654 is? I say it because I subspecialise in waterproofing. Should a site supervisor know what AS 4654 is? Should he have a copy of it on site? Maybe the answer today, we'd say yes, because we're so aware of these waterproofing claims and the building commissioner going on about waterproofing defects and everyone complaining about it. But 8 years ago, well, I had a bit of a leak. You know what I mean? You see how things are changing? Inspect the installation of the water and verify compliance with the building contract, right? This is the site supervisor, the project manager. Now, if you're a project manager and you're a project manager of 5 different sites, are you going to go to site and actually check the waterproofing? Maybe not. But if the company's not that big and the project manager does, well, he's expected to do it. If he's not expected to do it personally, he's got to make sure that the site manager does it. Okay? But at this point, when we're doing our evidence, when we're pleading, we don't know. So we cobble all of this in there. And it's a matter of evidence whether they have breached this or not, whether they've satisfied these requirements. We just don't know. Implement a quality assessment, quality assurance system, inspections at critical points to basically say this is what we're satisfied that we've met the requirements of the contract. Let me throw this out there. How do you determine what the critical points are? I saw that there's a regulation under one of the regulations under the Environmental Planning Assessment Act that talks about critical inspections that apply to private certifiers. If you look at that provision, it's, I think, clause 61 in one of the regs. It says that only 10% of the waterproofing is required to be inspected. Does that mean that if you're a superintendent or if you're a project manager or a site manager supervising the waterproofing contract, that only 10% is required to be inspected? Well, let's just see where the evidence takes us. That's what we're looking at. That's the grey that I'm talking about. We just don't know, okay? But we've got to set this out. And in cross-examination, we'll find these things out. But as an expert, these are the things that we have to say. Do every one of these apply to every one of these people, Ted, Jack and Sam? Maybe yes, maybe no. The evidence will figure that one out. But for now, we've got to put it in there. This is the last subheading that I've got. If the above steps are taken, would the defect have arisen or continued to exist? There's my answer in relation to those particular people. Okay? I am pressed for time, so I'm going to zip through quickly, and I hope I've stimulated some thought around what we're looking at. I've got Super 1, Super 2, and Super 3. This is in relation to that very same defect. So in my report, I've got Section 1 relates to the project manager. Section 1A applies to the super. Section 1C applies to the architect if the architect, I found him somehow involved in that process. In this case, this is the superintendent. The reason I have Super 1, Super 2 and Super 3 is because in this particular case, the superintendent was a project management company that employed 3 different people. One was the superintendent, one had certain delegated responsibilities, and one was a poor bloke that was employed by the superintendent company, didn't really do anything on site, but he was the person that signed a piece of paper that sort of confirmed OC, and the argument will be, well, he had his hand in it, he turned a blind eye, he signed it, to which I say, well, I can't really see how he's got control over what's going on, but we don't know because the cases aren't there yet. The reality is, though, he does to a certain extent have control because in the absence of that signature, in the absence of that document being filed with the appropriate authority or whatever it be, the works haven't been completed. Okay? I've highlighted these in blue, and this is to answer your question, sir. How's the superintendent responsible? Well, the superintendent plays a very key role in ensuring whether the works are being performed in accordance with the contract or not. Okay? You're not going to reach practical completion. You're not going to end the defect liability period. Superintendent has got a role to say, that's defective work. Hey, builder, fix that work. And if you don't fix it, I'm going to pull it out of your contract, get a third-party contractor to fix it, and I'm going to take the money out of your contract to pay that third party. They have control if they're doing their job correctly. Okay? Does that extend to the poor guy that's employed by the superintendent company that just signs a piece of paper that goes to OC? Maybe not. Probably not. But that's the territory that we're in. This is a really important one as well. The superintendent's got that power. I mean, let's face it. You're a head contractor. You got dodgy work done by your subby. Don't pay him. You've done dodgy work. By paying them, I won't say you're accepting it, but you're conspiring to the crime, are you not? So do you see how Section 37 works? It's very, very broad. It's all encompassing. There are a lot of people in the firing line, okay? And ultimately, where this is all going to lie, we don't know. We're waiting for the cases. But hopefully what I've impressed upon you is, unlike the home building claims where it's contractual, you have to express terms of the contract, implied terms of the contract, implied warranties, it's fairly black and white. Running a case in a Section 37 claim is very complicated. It is very time consuming. I will say this, I'll openly disclose it. I was involved in a case not too long ago. I did the liability side of things under your traditional Home Building Act claim. I incurred about $30,000 of WIP of my time to produce that report. There were 14 defendants in this, and it was actually quite complicated how those 14 interacted with one another. My WIP ended up being $85,000. Now, does that mean it's double or triple to run a claim like that? No. But what it means is if you've got multiple parties and all of these complexities, it is more complicated and far more expensive. I just want to finish off on one thing, Sharon, if that's okay, and it's only going to take me a couple of minutes, so I hope I haven't gone over the extension of time period. Another issue is, under the Section 37 claims, there's a defence of contributory negligence. Okay? I've pulled up this particular decision because it's the only one that I can see that has come up. But also, I was originally instructed on this case. And I think the owners, I gave them an answer they didn't like, and they decided to go with another expert. Okay, which is fine. What was interesting about this particular case, it was about, one of the issues was that the builder didn't comply with the approved plans. We had water coming in the basement and so forth and all that sort of stuff. He was successfully sued for breach of Section 37. He raised a contributory negligence defence and tried to argue a couple of points, stuff like the owners didn't give me the DA condition, so therefore I wasn't aware of this. Raised up some pretty frivolous thing. The judge went through it and dismissed them all, right? But I must say, let's be frank here, in the construction industry, dodgy things happen, okay? Dodgy things happen contractually. But just remember Section 37 is stepping outside the contract, okay? So when dodgy things are happening, like, oh, let's build the further extension even though it's not approved, and oh, don't worry about this and don't worry about that. See that sort of collusion, you can see how the argument will run. Well, I'm the builder. I've built this dodgy thing, and under a Home Building Act claim, it might be the case, well, it's a breach of the Home Building Act. You haven't complied with the codes and so forth and so on. But in the Section 37 stuff, well, I've been instructed by the owner. They were fully aware. They knew what was going on. In fact, they knew it was illegal. Some interesting points. So I've just pulled out that decision. Have a look at those paragraphs. That's one of the decisions that I've seen where the judge has actually gone through a full Section 37 to do that analysis. I must confess, didn't go into detail much at all about the stuff that I've shown you previously in terms of, well, where does the duty start, where's the breach start, and so forth and so on. But spent a bit of time talking about contributing negligence, and I thought it was important to bring it up. Thank you.
I hope we haven't scared anyone off. As we always say, it is better to know what your rights and obligations are. I hope you found this interesting and useful. I love the passion that these gentlemen both have. As law nerds, the lawyers in the room get excited about this kind of stuff. So the excitement that you see in the Georges are often the excitements that we have when we're making a coffee downstairs. Does anyone have any questions? It's clear that a claim, as I said, under the Home Building Act is easier to make than a claim under the DBP, and where we can, we just go under the Home Building Act for the reasons set out by George in terms of the evidence requirements under DBP. You can, though, claim for far greater things under the DBP and against far more people, which is why we would go under DBP. Any questions before we head out for more drinks and nibbles?
Sharon, just one. Who determines what claim it comes under? Is it normally the lawyer that makes that decision?
Yeah, look, in consultation, it will come down to, are you within time? 6 years, 2 years. If we are within time, the recommendation generally would be Home Building Act. It's easier, it's simpler. If the builder and developer are not around anymore, there's no insurance for various reasons, it wasn't required, they didn't get it, then if we have no one else to go after, we will start looking under DBP. Can we go after the architect, the engineer, the waterproofer, who is around? And we will start trawling through those documents and doing searches to work out who is still around. Who can we go after? That is how we'll do a whole investigation process. Generally, we will stop at HBA if that's a simple HBA claim, and we can go after them and they're around.
Just one question. Being one of the youngsters here, we always refer to the letter of instruction.
Yep.
I think both our speakers tonight have put forward a very good case to say the initial letter of instruction. I think there should be following letters of instruction based on reports.
Based on reports. We will often amend or supplement our letter of instruction. Or if we get, often it will be a phone call to the expert to say, we're going to send you some documents. Tell us what questions you need us to ask you in our letter of instruction. What do you want to, what answers do you have to the questions that I need to ask? I'm pretty sure there's a game show in there somewhere, but often we will say to them, what do you want us to ask you? And that avoids then numerous letters of instruction.
If one of the builders doing the construction work ceases to dies and there is a claim.
If the work is complete and the builder dies or disappears or goes insolvent, then it will be, if the work is complete and they died as a builder go insolvent, we would make a claim against their insurance, the HBCF. That is when it is triggered. If there is no insurance, then there is no claim. Assuming the builder was a sole practitioner and not registered as a company, then we would look to others who else is around for us to claim against. If it's a director of a company who has died and the company still exists, then the claim actually lies against the company and not the director himself or herself. Okay. Thank you, everybody. A huge thank you to George and George for coming in tonight. We're very grateful. Thank you for sharing your passion and your expertise. Thank you also to the colleagues in the room from the construction and strata team. We are all wearing a purple name tag. Please feel free to ask them any other questions that you may have. They're here to help, so feel free to introduce yourself. Otherwise, please grab a drink and some food. Thank you, everyone.